All right, let's dive right into this explainer. If there is one single area where property managers bleed money, completely wreck resident relationships, and just invite totally unnecessary legal headaches, it's the security deposit disposition. Navigating property management can feel like a giant puzzle, right? Especially when we throw California's civil code into the mix. But as we always say here, complex doesn't have to mean confusing. Today we're unpacking the California pre-move-out inspection workflows. We are literally going to take a super dense legal requirement and turn it into a slick, highly organized system that protects your team, saves your resident relationships, and, most importantly, keeps everyone far away from small claims court. Let's get into it.
Here is our agenda. Basically our roadmap to turning all that legal jargon into a bulletproof operational system. We're covering 1. California legal requirements. 2. Scheduling and entry notices. 3. Conducting the visual walkthrough. 4. Wear and tear versus damage. And finally, 5. Professional communication. Let's jump right in.
Section 1, California legal requirements. Let's lay the groundwork with Civil Code Section 1950.5.
So, foundationally, under state law, residents absolutely must be informed of their right to request an initial pre-move-out inspection. And what's really crucial to grasp here is the actual intent of the law. This process is just a preliminary check. It is definitely not the final security deposit disposition. The whole idea is to spot visible issues and give the resident a totally fair, actionable chance to fix them before they hand over the keys. We're not doing final math here, no calculating paint costs or labor hours. We are just giving them total transparency so they know exactly where they stand.
Okay, let's move on to Section 2. Scheduling and entry notices, where we look at your actual operational workflows. The transition between a resident giving notice and actually moving out is, well, usually chaos, so the timing here is incredibly strict. Step 1. The inspection legally has to happen within the 14 days right before the lease ends. Step 2, you've got to give a 48-hour written notice before going in, unless the resident waives that in writing. And Step 3, you give them the opportunity to correct the issues. This timeline exists for one massive reason: to give them a real, actual chance to fix things. If you do this the day before they move out, yeah, you've completely defeated the purpose of the law.
As you're setting this all up, you're going to hit a fork in the road. Is the resident going to be present or not present?
People are busy, right? Some want to walk through every inch with you, and others want nothing to do with it. So you have 3 resident response options to track. 1, they decline the inspection entirely. 2, they request it and want to be there. Or 3, they request the inspection but authorize you to go in without them. You must, and I mean absolutely must, document which path they choose. If a resident skips the inspection and then tries to fight a deduction in court months later, your documented waiver is literally your best line of defense.
All right, moving right along to Section 3, conducting the visual walkthrough. Let's talk objective observation. Fast forward to inspection day. You're at the property. Now this is where you have to be super careful not to overstep. Your role, you are an objective observer. This is a visual walkthrough only. That means no speculation, no legal conclusions, no repair estimates, and absolutely no guaranteed deductions. Please do not go pulling up area rugs or dragging heavy couches away from the wall to check baseboards. You are strictly looking at what's plainly visible. You're essentially just a camera, documenting the physical reality of the space at that exact moment.
And that perfectly tees up Section 4, wear and tear versus damage, and how we actually evaluate these conditions.
This is the big one, the source of almost all move-out friction. Before you write a single thing down, you have to know what normal wear and tear actually is. It's the normal deterioration over time considering the item's age and useful life, assuming there's no misuse or negligence. Think about it. A 5-year-old builder-grade carpet is going to show some traffic patterns just from someone living their daily life. If there's no severe accident or intentional misuse, that's just natural aging. You simply cannot charge a resident for time passing.
Let's look at a quick comparison to really separate the two. On the normal wear and tear side, we've got minor nail holes, maybe a small wall scuff near a door, faded paint, standard carpet wear. But over on the potential tenant damage side, we are talking large wall holes from a TV mount, broken plumbing fixtures, deep pet urine stains, or literal burns in the carpet. See the difference? When we totally remove the emotion from it, the severity and the intent make the dividing line incredibly obvious.
So, here is the golden rule of this entire process. The goal is objective documentation, not immediate judgment. Final determinations only happen after the keys are turned in and the unit is vacant.
Remember, they still have time to patch that drywall or scrub that oven. You aren't playing judge and jury today.
Finally, let's wrap up with Section 5, Professional Communication and Documentation.
Knowing what to look for is great, but how you record it is everything. Let's look at photo documentation standards. You want clear and well-lit images. You need multiple angles for any major conditions. Timestamp them whenever possible. And make sure you get consistent coverage of all the rooms and exterior spaces. Doing this isn't just administrative busy work. It is your ultimate safety net. If a deduction is challenged way down the line with a classic, "It wasn't like that when I left" argument, these photos are your absolute proof.
Your vocabulary matters immensely too. Imagine reading a note that says, "Visible staining observed on carpet." Contrast that with, "You ruined this carpet and you're paying for it," right? Keep it completely factual. Say exactly what is physically there, like heavy grease buildup observed on stovetop, and completely strip away the emotion or blame.
To make this super easy, here's a brilliant little workflow hack you can use on your actual inspection forms. Just use a simple 3-letter coding system. S means satisfactory or clean, no comment needed. O means other, and D stands for potential deposit deduction. If your team uses an O or a D, they just add a brief, factual comment next to it. It stops people from writing emotional essays and keeps your records perfectly objective and clean.
Now listen closely to this one, because it has massive financial implications. Under California law, landlords generally may not deduct for visible issues that were not identified during the pre-move-out inspection if the resident could have fixed them. Let that sink in. If there's a visible hole in a door and you rush through the walkthrough and forget to write it down, the resident is inherently denied their legal chance to fix it, and because of that, you generally lose the right to charge them for it after move-out. Thoroughness is absolutely non-negotiable.
Which brings us to our final question for you to ponder. Have you built a workflow that prioritizes objective, factual documentation over immediate subjective judgment? Challenge your team with this before their next pre-move-out inspection. Are they reacting emotionally to a messy property, or are they calmly following a structured system? Getting this right completely eliminates friction, seriously protects your assets, and ensures fair treatment for everyone involved. Thanks so much for exploring this framework with me today.